Get started.
Thank you, Anna. Hi, everybody, and good afternoon, and welcome to our webinar today. Our webinar is on removal proceedings, pursuing legal relief for immigrant survivors of domestic violence and sexual assault. And my name is Amy Cheung, and I'm joined today by my wonderful colleague, Flores Bachman. And we both are with we're both with ASISTA Immigration Assistance, which, if you're not already familiar with us, is a national organization that provides training and technical assistance and litigation support for attorneys and DOJ accredited representatives who are representing immigrant survivors of violence. And we're also very grateful for the support of the Office of Violence Against Women through the U.S. DOJ, which is supporting the webinar today, as well as all of the work that we do with OVW grantees and STOP grantees such as yourselves. And then one final administrative note before we get started with today's content is that today's webinar has been approved for 2 hours of substantive credit with the Texas Board, the Texas Bar. So if you are licensed in Texas and want CLE credit for attending today's webinar, you should have input your bar number into the registration form when you signed up for today's webinar. If you didn't do that, or if you're barred in another state and would like a certificate of attendance to submit to your own state bar, please email us after the webinar and we can make sure to get the certificate of attendance to you. And I'm putting the email addresses into the chat box right now. So these are the ones that you should contact if you have any issues. And of course, if you forget those email addresses, you can always contact Laura or myself and we'll get you to the right place. Okay, so with that, let's get started. Oh, so one other note is that today's webinar is being recorded. And so we'll be sending out an email after today's session with the recording, the materials again, so that you have all of that for your records and for future reference. Okay. All right, and so the objectives of today's webinar are that by participating, participants will be better able to identify survivor-based arguments for termination and continuation of proceedings, as well as assess eligibility for survivor-based remedies that fall within EOIR's jurisdiction. And just as a note of preface, we decided to do this webinar partly because we were getting a lot of TA questions from OVW grantees about representing clients with pending U visas and other types of applications who are in removal proceedings. And we were also getting questions about things like asking for substantive relief in immigration proceedings. And we also recently did an in-person training on this material. So we wanted to make sure that you guys got some of the key points from our in-person trainings, and also so that we could talk about some of the key issues surrounding survivor removal defense as it comes up in your work. Okay, so let's get started with a couple polls so that we can see how the level of experience is and the variety of experience that we have in the audience with us today. So the first poll is, I have a client who has received an NTA or a notice to appear from the Vermont or Nebraska service centers after being denied a humanitarian application. And Anna, could we pull up the poll on this? Great. So if you could select your response here, and we're just going to give it a minute to give everybody a chance to respond. These polls are completely anonymous. Nobody's tracking who's responding how or anything like that. It's just to give us an idea of the experience level that we have in the webinar today. Okay, we can go ahead and end the poll. Could you pull the results back up so that we could talk about them? Sorry, I jumped the gun. Okay, so in the meantime, the results were about 87% no, and then the remainder were yes. So that's really helpful to know. We've gotten a lot of interest in training on removal proceedings, but it is good to know who has experience and how much experience people have. A lot of the things that we're going to be talking about today are, I would say, intermediate to advanced, but we'll be sure to explain terms. And if you do have any questions as we go along, please put them into the chat box so we can address them. All right, next poll. Okay. And the next one is, I have represented clients in removal proceedings before. Can we pull up that poll as well? So this isn't necessarily clients with humanitarian applications or anything like that, just general removal proceedings experience. Okay, so it looks like it's about half and half. And then the other thing I said, but I forgot to say about the last poll, was that it's not surprising that most people haven't received an NTA yet based on a denied humanitarian application. We have heard of a handful of cases for both denied U and denied T applications where the applicants did receive a notice to appear from either Vermont or Nebraska and were placed into proceedings. But there has been so far only a handful that we've heard about, so it doesn't appear to be across the board yet. And it's not entirely clear how the NTA policy memo that came out last year is being implemented. But we are starting to hear stories that it is being implemented here and there. And then the anecdotes that we're hearing vary a bit. In general, I would say that the NTAs are being filed with the court after the appeals and motions period for the 290B has expired in general. Okay, so let's close that poll. All right, so the first substantive topic we're going to get into today is really focused on termination of removal proceedings. And when we're talking about termination proceedings, oftentimes we're talking about respondents who may not have a very good claim for substantive relief in removal proceedings. Because if, for anybody who's not familiar or not very familiar with removal proceedings, it consists of two phases. You've got the phase where the judge is determining whether or not your client is removable at all. And then if your client is removable, then whether or not they're eligible for relief from removal. And you have a lot of people who are placed into proceedings based on allegations that they're removable, but these people may or may not be eligible for relief in removal proceedings. They may or may not be eligible for cancellation, asylum, withholding, or other types of relief that can be presented in immigration court. And termination arguments can be presented for any respondent to whom they apply. But I think they are especially important for those respondents who don't have a very strong claim for relief in immigration court. Because the thing to remember about termination is that if you win your argument for termination, then proceedings are terminated, but your client still has no lawful status if they didn't have any to begin with. So if you have a client who is eligible for relief from removal, who's eligible for a substantive benefit like cancellation or something that's going to put them in lawful status, then oftentimes you might strategically choose to go with that option instead. In general, when we're talking about termination, we're just going to do a very brief overview today. This topic could involve many, many hours of discussion and training and materials. But just as part of our discussion today, we're going to be talking about statutory requirements for NTAs, for service of NTAs or notices to appear, and pleadings. So are the allegations in the charge that ICE is bringing correct? Can DHS, the Department of Homeland Security, meet its burden to show that your client is removable? Right. So let's talk about statutory issues. The general statutory requirements for notices to appear come under INA 239. And INA 239 discusses briefly service of process, as well as what must be contained in the notice to appear itself. So when we're talking about the service of process, there are a few different kinds of service that are specifically permitted under the INA, that they include personal service on the respondent. This is most common if you have a client who crossed the border and was apprehended at the border and was issued an NTA at that point. So far, we have not seen any personal service for people whose humanitarian applications were denied by Vermont or Nebraska and then placed in proceedings that way. For those cases, the NTA has been served through the mail, which is also permissible. Service on the attorney of record is also permissible under the INA. I think one question to consider is, what does the INA mean by counsel of record? Counsel of record could be counsel of record in removal proceedings, but essentially what USCIS is saying is that counsel of record includes the attorney of record before USCIS on the humanitarian application as well. It's not entirely clear that that is actually what's contemplated in the INA when they say that service can be effectuated on the counsel of record. So I think that's one thing to consider as you, as the attorney of record in the humanitarian case, are receiving an NTA for purpose of service on your client. In terms of service on minors, which comes up in humanitarian cases a lot with respect to derivatives, the statute is silent on what is required for service on minors, but there is a regulation that requires that if the minor is under 14, that the NTA has to be served on the person with whom the child resides, right? So you can't just serve a child under 14 to the child itself, right, or him or herself. You would have to serve the person with whom the child resides. And so there are a series of BIA cases on this that interpret it. I think one of the challenges in making service-based arguments is that oftentimes the BIA will say that if the service did not comply with the regulations or with case law regarding service on minors or service on incompetent individuals, that DHS should be allowed a continuance to try to perfect the service, to re-serve the individual. You might find some immigration judges who are much more amenable to termination-based arguments when you have service issues. Oftentimes, DHS would appeal those kinds of decisions, and you may be in a position of trying to get the BIA to agree that termination was proper instead of an opportunity to re-serve or continue the case. But that's one of the issues that's been coming up lately on these. And then one of the issues that's been hotly litigated for the last year or so has been, does the NTA have to contain the time and date of hearing in order for jurisdiction over removal proceedings to vest in the immigration court? The argument around this stems from INA 239, which says that the NTA must contain the time and date of hearing, as well as a discussion of that requirement in Pereira v. Sessions, which is a Supreme Court case from last year. Pereira v. Sessions was specifically talking about cancellation of removal and the stop time requirement, which we're not going to get into today at all. But a lot of practitioners were making the argument that the reasoning in Pereira v. Sessions could be extended to the validity of the NTA at all for respondents whose NTAs did not contain the time and date of hearing, which most of them don't. The BIA has issued a number of decisions on this argument since Pereira v. Sessions that have said that jurisdiction does vest, that the issuance of a subsequent notice of hearing that has the time and date of hearing would perfect the deficiency of the NTA. So far that has been unsuccessful, but the Supreme Court hasn't addressed this yet, so we're still encouraging people to consider this argument as it comes up in their cases. And you can reach out to us or really any number of other organizations that have been working on these issues since Pereira came out.
And Amy, before we move on, just a couple of basic practice pointers as to the first part in terms of service of process. Sorry, the first part of our slide here. In terms of service of process, just a quick practice pointer. If your organization only has the ability in a particular case to represent the individual affirmatively, two things. First, make sure that your contract for services or your agreement with your client, your written agreement with your client, includes with specificity, for example, a valid self-petition and adjustment of status. You can present in front of the court, but you want to specifically include in your agreement that you're only representing them in the affirmative application of a valid self-petition and adjustment of status before USCIS. Be specific of which agencies your representation includes, right? And then the second part of that, in terms of a practice pointer, is if that is going to be the extent of your representation, once the case is completed in front of USCIS, so you've received a decision from USCIS or from the AAO if you decided to take it before the AAO, and now it's before the immigration court, make sure to immediately, once your representation has ended, immediately notify USCIS that you no longer are attorney of record, right? And this may help you, this may help the client in terms of whether there was proper service, or at least in making an argument of whether there was proper service if you no longer are attorney of record. So I just wanted to point out those couple of things.
Thanks, Laura. That's great. I think the other thing is that if you're an organization that does not represent people in removal proceedings, that it would be helpful for your clients to try to coordinate with another organization or have a referral list of attorneys to whom you'd be able to refer your client if they are in removal proceedings or if they're placed in proceedings. And those are referral relationships that you can develop even before any of your clients are NTA'd by Vermont or Nebraska after denial.
Yeah, absolutely. I think that's a great point. Be thinking of those relationships before you even start representation. I mean, at this point, really, you have to be looking at the long view and the potential of an NTA. So yeah, absolutely. Making those relationships will be important.
All right. Okay. So the arguments that we were talking about before could apply to anybody, not just survivors. But there are also some very specific survivor-based arguments for procedural challenges to removal proceedings and for termination. So one of them comes under 8 U.S.C. 1367, which is oftentimes called valid confidentiality, but goes much broader than just confidentiality. 8 U.S.C. 1367, in addition to prohibiting the disclosure of information about protected individuals, also says that the determination of inadmissibility or deportability may not be based solely on information provided by the abuser or other people in the abuser's penumbra, such as the abuser's family member, abuser's household members. And so one of the things that you should look at when you get an NTA for a client who's protected under 8 U.S.C. 1367, which includes VAWA self-petitioners and UNT petitioners, among others, are what are the allegations of inadmissibility or deportability that DHS is making, and what is their basis for those allegations? Where do they get the information to make them think that those allegations were true? If it's information that you think might have been coming from the abuser or people connected to the abuser, then I think it's worth considering whether to deny those allegations and make DHS explain how they got that information to substantiate the allegations, because there is a statutory prohibition on this. One of the issues that we see is that DHS's interpretation of this focuses on the word solely. And so their position is that even if they did get a tip-off from the abuser or somebody connected to the abuser, that they would then be able to corroborate that information and use that to determine inadmissibility or deportability. Our position is that that strategy is stripping away the protections that were built into the statute. I mean, the statute is clearly meant to be protective of VAWA and U and T petitioners. It's meant to diminish abusers' ability to use the immigration system against their victims, right? And so if you have DHS using the tips from an abuser, people connected to the abuser, and using the fruit of the poisonous tree, if you will, to try to establish inadmissibility or deportability, then that raises real questions about whether or not they're stripping away the entire protective effect of the statute to begin with. The other thing that comes under 8 U.S.C. 1367 is that ICE has to certify compliance with the statute if the enforcement action took place at a prohibited location. And the prohibited locations are arrests at DV shelters, rape crisis shelters, family justice shelters, victim services providers. There's a whole list of locations at which DHS is typically not supposed to be doing enforcement action. And so if they do an enforcement action at one of these prohibited locations, then they would need to certify compliance with 8 U.S.C. 1367 on the NTA itself. So if you have a client who was arrested at a prohibited location, look at the NTA to see if that certification is there. And if it's not, then that NTA is deficient and is not compliant with INA 239E or 8 U.S.C. 1367. So it gives you potentially another argument for termination. All right. Next up, let's talk about the allegations themselves. So Anna, could we pull up the poll? And then this poll is, when representing a client in proceedings, I have denied the allegations and the NTA before. And this could be for humanitarian or non-humanitarian based cases. Just going to give it a couple more seconds here. Okay. So it looks like we've got 43% saying yes, 26% say no, and 30% have never represented anyone in proceedings. So that is really great. One of the things that we see a lot is that practitioners will reflexively admit and concede the allegations in the NTA. There are times when that makes sense, but it should be a considered decision. It should be a strategic decision how you're pleading to the NTA. Can we close this poll? Great. Okay, so when you're pleading, we're recommending that everybody check for the accuracy of the allegations and the charges. Make sure that your client is properly charged. If your client is inadmissible, then they should be charged under Section 212. If they have been admitted to the United States, then they should be charged under 237 for deportable individuals instead. If the charges are incorrect, then you should deny those allegations, deny those charges, and argue for termination. Also, it might seem like a minor issue, but in the allegations will typically indicate when the client entered the United States and how. Is the manner and date of entry correct? This might not seem that important, but it could have real implications for the accrual of physical presence for a VAWA cancellation. You have to have 3 years of physical presence. If you're doing a non-LPR cancellation, it's 10 years. So the date of entry certainly would be important there. Also, potentially for the calculation of the accrual of unlawful presence, if that were to come up in your case or come up in the future. And so you just want to make sure that all of the details in the NTA are actually correct. And then the other issue, yep, go ahead.
Oh, sorry, I was just going to say one more point on that, on how the manner and date of entry can also affect your client. Even if the relief that you're seeking in front of the immigration court is completely separate from the actual relief that your client is eligible for example, a U visa, which you would apply for in front of USCIS, it's important that the manner and date of entry are that your client concedes to is consistent with the information that your client has given as far as the manner and date of entry in their I-918, right? So if your client is saying, yes, I admit that this is the way I entered, but then on the U visa application, the information is completely different. Remember that can still be, if ICE wants includes that in their file, obviously that file is accessible by USCIS as well. So you want consistency.
Thanks, Laura. And the other major consideration when you're pleading the NTA is that DHS has the burden to prove alienage, right? So one of the main issues for establishing removability for any respondent is that your client has to be not a citizen or national of the United States, right? So if you're admitting that and there's no other evidence in the record that your client is not a citizen or national of the United States, even if they're not, that's DHS's burden to prove. So especially if your client is not eligible for other forms of relief in immigration court, it can be really important to make DHS meet its burden. It's DHS's job to prove this, and if you concede it, then you are relieving DHS of their own responsibility to prove their own case. As I mentioned earlier, these arguments can sometimes make more sense to make when your client does not have a strong case for relief, because if the proceedings are terminated, if you win your argument, then your client is still left without lawful status, whereas if they had a strong case for relief and presented that, then they could end up with lawful status, which would obviously be much better for your client. I think there are also some considerations around what you're going to be asking DHS for in the future. So if on this case you're going to be looking for some cooperation or concessions from DHS, you may want to consider what is your goal in raising all of these arguments for termination, contesting alienage, and things like that. You certainly can do it. Your client has a right to make that argument and contest it, but strategically, sometimes there are other considerations at play.
And I'll just make one point here as well, is if you are going to contest alienage and make DHS, or have the judge make DHS meet its burden of proof, don't be afraid, which is easier said than done, but don't be afraid when the judge gets annoyed with you for making DHS meet its own burden. There are some judges who just want to move things along. As we've all heard, IJs have serious time constraints, huge case logs, and there are just some judges who are just cranky, right? So unfortunately, based on whatever level of pressure they have to move cases along, at times making those objections and saying DHS hasn't proven its burden, or denying alienage and saying that DHS hasn't proved its burden, you will get pushback not just from DHS, but actually from the judge, him or herself. So be prepared for that. Have your arguments ready. Being prepared is, basically be prepared of what you're going to say when the judge says, "Are you kidding me, counsel?" So it's interesting that we have to prepare not just arguments, we also have to prepare ourselves, psych ourselves up to be able to speak through that, right? Have your notes ready. This is just super basic, practice tips, right? But even if you think you know your case backwards and forwards, have something in writing ready to respond to the judge so that if you get nervous, you can literally just read it. So that's my only practice pointer there.
Thanks, Laura. And then finally, when we're talking about survivor-based challenges, there's one that we want to make sure that everybody is aware of, because we don't see people using it very often. And for some people, this is potentially a very strong argument. So there is an exception to the ground of inadmissibility at 212A6A. This is the ground of admissibility for people who are present in the United States without admission or parole. And this is an exception as opposed to a waiver, right? The difference between exceptions and waivers is that exceptions, if you meet the criteria, don't apply at all. So the VAWA exception to 212A6A is that if the respondent is a VAWA self-petitioner, and VAWA self-petitioner is defined under the statute as not just people who have a VAWA self-petition, right, or who qualify for a VAWA self-petition, but also people who qualify for an I-751 petition for removal of conditions based on domestic violence, as well as other people who qualify under like certain Nicaraguans, Haitians, and Cubans who've experienced domestic violence. So the definition of VAWA self-petitioner is much broader than just VAWA self-petitioners. It includes children of self-petitioners as well. So if your client is a VAWA self-petitioner who suffered battery or extreme cruelty, or their child suffered battery or extreme cruelty, and there's a substantial connection between battery and extreme cruelty and the unlawful entry, then this ground of inadmissibility does not apply to that client. And so if you have a client who is, let's say, a self-petitioner, and you are trying to adjust this client before USCIS, but your client is in removal proceedings, if they're charged under 212A6A, this is a really great argument for termination, that this ground just flat out does not apply to your client, assuming that she meets or he meets all of these criteria. And as I said earlier, we don't see a lot of people making this argument. I've only found one case that in which somebody tried to make it. And unfortunately, in that case, that respondent was actually not a VAWA self-petitioner, even under the broad definition under the INA. So that was unsuccessful. But in many of your cases, your clients will actually be VAWA self-petitioners. And this is something to consider if your client is either trying to adjust before USCIS or is for some reason not eligible for relief and removal proceedings, and you're trying to terminate proceedings there. And if you're looking for help in making this argument, please let us know, because we'd love to work with you on that. Okay, and Laura, I think you are up.
Okay, thank you. So what if you now are at the point where you have pleaded and your client is eligible for some relief or would like to obtain relief in removal proceedings? We're going to talk a little bit about that now. And so we'll start by what does the judge have jurisdiction over if you have a client who is a victim of violence, right? So we'll start on the left-hand side of this chart. The immigration judge does not have jurisdiction over U&T non-immigrant visa petitions. The judge also doesn't have jurisdiction over adjustment of status, over the VAWA self-petition, so the I-360, or over the initial review of the I-751. And the I-751 is a waiver for joint petition to remove conditions on permanent residence. So if you're filing an I-751 waiver so that your client does not have to jointly file the removal of conditions based on VAWA or extreme hardship, that first goes to USCIS, but the judge then can review it. So on the right side, what does the judge have jurisdiction over? The judge has jurisdiction to look at 212D3 non-immigrant waivers. So there are non-immigrant visa waivers for grounds of inadmissibility under INA section 212D3, and UNT visa applicants are eligible to apply for 212D3 waiver in addition to the waivers that they are already eligible for under 212D13 for T's and under 212D14 for U's. And in some jurisdictions, 7th and 11th circuits specifically, the circuit courts have found that the immigration judge can adjudicate an application for a 212D3 waiver by a U or T non-immigrant, well, I guess in those cases it was specifically a U non-immigrant visa petitioner. So even though the judge didn't have jurisdiction over the actual I-918 or I-914, the circuit courts found, yeah, generally the IJ does have jurisdiction over a 212D3 waiver. And that can be important because then you get the opportunity to present a waiver for grounds of inadmissibility in front of the judge, in addition to making the arguments in front of USCIS. So currently, that's only available if your client is under the jurisdiction of the 7th or 11th circuits. The 3rd Circuit has specifically found that IJs do not have authorization over the 212D3 waivers for UNT non-immigrants since they don't have jurisdiction over the underlying non-immigrant visa petitions themselves. BIA and matter of con, which I believe is in your materials, that was their finding as well. So that's possible. What else can an immigration judge have jurisdiction over? What can you apply for? You can apply for adjustment of status for a VAWA self-petitioner. So if you have a VAWA self-petitioner who is placed in removal proceedings, you can present that application for adjustment of status before the immigration court after USCIS has approved the I-360. And then, as I mentioned, the I-751, and then finally you have VAWA cancellation. So let's take a look and break this down a little bit. Okay, so let's start with adjustment of status. So for a VAWA self-petitioner who is going to seek adjustment of status, the good thing about this form of relief, if you're in front of the immigration court, is that there's no annual cap, so there's no limit on the number of adjustment of status that can be granted before the immigration court. But what do you have to make sure of? Well, you have to make sure visas are available, right? So the same requirements that you would have to file for adjustment of status before USCIS, you're also going to have to show in front of the immigration judge. So if you have a VAWA self-petitioner who has an approved VAWA self-petition, but the abuser is a lawful permanent resident, and so therefore your client is waiting for an immigrant visa to be available, then just like they would before USCIS, they would have to wait for an immigrant visa to be available. So what happens in that situation, right? What do you do if your client does not have an immigrant visa immediately available? Unfortunately, the immigration judge will say, well, counsel, it doesn't look like you're eligible for adjustment of status, so I cannot proceed with an I-485 because there are no visas immediately available for your approved VAWA self-petitioner. Can they get deferred action, right? So normally, if you get an I-360 approved, they get deferred action. But if your client is already in immigration proceedings, no, USCIS will not issue deferred action at that point, unless you get ICE to join in the motion to terminate, right? So that is one possibility. Is going back to what Amy mentioned before is you can file a motion to terminate for various other reasons, and having the possibility of relief before USCIS can be one of those reasons. So let's say you're in front of the immigration judge. The judge is saying, okay, we have to proceed with what relief is available. You ask for a continuance to get the I-360 approved. You get the approval, but there's no visas available. At that point, talk to the Office of the Chief Counsel for ICE. talk to them about the eligibility of your client to deferred action if they are not in removal proceedings. Go into all the sympathetic reasons why that would be appropriate, et cetera. Not always foolproof, but that's one possibility that you might want to seek that option. If not, if your client is so that's dealing with clients who don't have visas immediately available. If your client is a spousal petitioner and does have a visa immediately available, priority date current, if she was married to an abusive LPR, which given the current processing times of VAWA self-petitions, we actually are seeing that many cases priority date is current because the I-360 took so long to adjudicate. So it's terrible in most cases, but if your client is in removal proceedings, it's actually helpful that there's a visa available. Or if the abuser is a U.S. citizen, then there's a visa immediately available. So if your client is not in removal proceedings, you file the adjustment of status before USCIS as normal. If your client is in removal proceedings, you submit the I-485 and all the evidence that you would normally submit for a VAWA self-petitioner who is adjusting to the immigration court. Just a quick practice pointer. One of the things that you would want to do if you're in that situation is try to get as much of the information. Try to get the ICE counsel to stipulate to as much of the requirements of adjustment, right? So that you can narrow it down to what are the issues that you want the immigration court to have before it, right? So if you're filing for adjustment of status and you've already established, your client's identity, your client was married, they're not going to get into the issues again of the I-360, but, that your client has this many family members, your client was a member, all the questions that are in the I-485, try to get as much of that stipulated with ICE counsel so that what you have before the immigration judge will just be, the bigger issues, right? So, whether your client is eligible for a waiver or something like that. What about if your client is in removal proceedings when you meet them, but those removal proceedings are administratively closed? Let's say this was, the case has been administratively closed since 2014, but your client is now eligible to file a self-petition. So you file a self-petition, you have an approved self-petition. If the immigration court proceedings have been administratively closed, can your client proceed with an adjustment of status application before USCIS? Unfortunately, the answer is no. Administrative closure is not the same thing as termination. Basically, administrative closure is essentially like the judge shelving the case, but not terminating the case. So jurisdiction is still with the Executive Office for Immigration Review, whether that's CIJ or the BIA. So in that case, you want to get your I-360 approved first, and then determine if they're eligible for adjustment immediately. Consider two options, right? And one is filing a motion to reopen in order to be able to apply for adjustment of status before the immigration court, or a motion to terminate in order to be able to apply for adjustment of status before USCIS. There's some, the court's kind of all over the place on this. Some don't want to terminate, some will. So I think knowing your court is important, but also, it does not hurt anything to try and get ICE to stipulate. I know that in this day and age that may not happen because sometimes it's, difficult to even get a hold of them before the court hearing, or, local ICE counsel is simply not allowed to join in motions. And so, but asking is is always important because you do want to let the judge know, hey, I made these efforts, and here's why a termination is appropriate. And we'll get into more specifics on that later. Okay, so that's generally adjustment of status. I also mentioned 212D3 waivers. And so this is an alternative waiver for U and T non-immigrants. And I'm just going to say, since it only right now, it's only available in the 7th and 11th Circuit, what I'll say is if you are in those circuits, it is helpful to have the immigration court be able to review whether the U or T non-immigrant is eligible for a waiver of grounds and inadmissibility. And the reason for that is usually that's what's going to hold your client back from relief generally, right? I mean, if they can meet the statutory requirements of U's and T's, sometimes it comes down to their inadmissibility and whether they can get that inadmissibility waived. And if you can get an IJ to look at a 212D3 non-immigrant visa waiver and approve that, then that might help your case that's before USCIS, the underlying U case that's before USCIS. So the difference between the D3 and the D14 is that let's talk about D3 first, right? So INA section 212 D3 has a very general waiver of inadmissibility that says, you know, an applicant for a non-immigrant visa may apply for a waiver of any ground of inadmissibility except for a few dealing with national security, et cetera, very specific security issues. And since the statutory standard is kind of general and just says, you know, in the discretion of the secretary, there's a BIA case, matter of Franca, and we have the actual case in your materials. The matter of Franca, basically the BIA came up with 3 factors for considering whether a waiver should be granted. So it's basically just a balancing test, right? So if there is a showing of seriousness, let's go back. You would want to show that the seriousness of the immigration or criminal violation that made them inadmissible is not, it does not put them at risk to harm society, right, generally. But you'd also want to show, you know, how long ago was it in showing whether it was a serious violation or a serious criminal violation. How long ago was it? What has your client done since then? If it was a serious criminal offense, then you're going to want to have a substantial amount of documentation showing that it doesn't affect that second factor, which is the risk of harm to society. And then third, of course, reasons for wishing to remain in the U.S. And this is very general, obviously. You can't just say, oh, my client would like to stay here because things are better here, right? Obviously, you're going to want to present stuff like what are their family ties. If it is a U or T non-immigrant, then you're also going to want to show, well, as a result of the harm that they have suffered from the underlying crime or trafficking, they're gaining resources in the United States. They have access to counseling. They have access to law enforcement. All of that can go into that third factor, reasons for wishing to remain in the United States. So the discretionary standard in matter of Franca is a little bit different than the discretionary standard in 212D14 for U visa applicants and 212D13 for T visa applicants. And so D14 specifically, which is what was being considered by the 2nd and 11th Circuit, spells out D14 spells out that the discretion with the Department of Homeland Security can be shown if it's can be exercised favorably if it's in the public or national interest. Very general and not the same factors as HRONCA, even though USCIS tries to apply those same factors. So what you should keep in mind and let the judge know is if you are in the 7th or 11th Circuit, or if you're trying to make an argument that that they should have jurisdiction over the D3, I think that the best argument for this is if Congress wanted U and T visa applicants to only have eligibility under D4, to only have eligibility under D3, they wouldn't have created a separate D14 and vice versa, right? And so it did, in other words, D14 doesn't divest the immigration judge from considering a D3 argument, simply because USCIS has jurisdiction over the 918. So generally, that's important to know if you're in 7th or 11th Circuit. If it's granted, you still have to go back to USCIS for adjudication of the actual U or T visa, but as I said, it puts you in a much better situation to get that approval. So let's move on to VAWA cancellation of removal as another form of relief before the immigration court. So some restrictions on VAWA cancellation of removal are that cancellation of removal can only be granted by the immigration court, which means client must be in removal proceedings. There is an annual cap for all non-lawful permanent residents who are seeking cancellation of removal before the immigration judge, except for those seeking cancellation of removal under NACARA. And that cap is $4,000 every year. The IJ can still go forward and consider your client's application for VAWA cancellation of removal, but if the cap has been met for that year, the decision is reserved. So the judge will hold their grant until a number is available. If cancellation of removal is granted, then the great thing is it leads to lawful permanent resident status. Unfortunately, cancellation of removal does not grant derivative status. So the children of the respondent won't be able to get lawful permanent resident status as a result of approval of cancellation of removal for your client. But they shall be granted parole. So that's a statutory requirement that if the parent is granted VAWA cancellation of removal, the derivative child shall be granted parole once that cancellation of removal is approved and the respondent is a lawful permanent resident. That parole is very helpful. Obviously, the child is granted parole, and then what are you waiting for? Well, you're waiting for visa availability. So in other words, your client would file a petition for the child, but unlike other cases, the child would be here under a grant of parole, can get work authorization under a grant of parole until such time as visas are available. Immigrant visas are available as the child of a lawful permanent resident. If that's not going to be an option, right? What if the child will no longer be a child when cancellation of removal is finally adjudicated, or when numbers become available? You want to look at what other options might be available to the child, whether the child, him or herself, is eligible for relief, so have their own self-petition, for example. What are the differences between...
So just one note before we move on. So with respect to the parole issue, anecdotally, we've been hearing that it is quite difficult for these children to actually get parole. So if you're encountering difficulties with this, if your client is granted VAWA cancellation and is trying to get their children, or if your client is a child or parent, parole, please let us know. We can help you try to work through it. Or if you've had success on getting parole for these individuals, then we'd love to hear about what your strategy was, because it can be quite challenging as a logistical matter.
Thank you, Amy. Yeah, absolutely. Sorry, I didn't mean to make it sound so easy peasy, right? They shall do it, and they do it. No, shall and getting it done are obviously two different things. But the great thing is that it is in the statute, and so yes, absolutely contact us if you're having difficulty in being able to get parole. The other thing I'm going to put in the chat box is, if it lets me do it here. Well, it might not let me do it. I was going to put in the link to the memo regarding the cancellation of removal cap, what the IJ actually has to do if the cap is met in a particular year. There is a memo.
So that's already in the files.
Oh, it is. Oh, okay, great. I wasn't sure if it was already. Okay, perfect. So take a look at that, because it goes through the steps of what the immigration judge does if the judge is inclined to grant cancellation of removal, but the cap has been met. So first, let's start with, on this slide, let's start with comparing what's the difference between cancellation of removal and a self-petition. In other words, if your client is eligible for a self-petition, then they might want to proceed with a straightforward, I-485 application for adjustment of status in front of the court. But what if they're eligible for a self-petition but not eligible for adjustment? For example, a particular ground of inadmissibility cannot be waived. Or another example that we see often is there is a false claim to U.S. citizenship, for example. That will keep your VAWA client from adjusting status, but may not keep your client from being eligible for cancellation of removal. So let's look at some of the elements. For the element relating to relationship to the abuser, cancellation of removal is not a benefit that is available to abused parents of U.S. citizens, unlike the self-petition, right? The self-petition is available to spouse or child of a lawful permanent resident and U.S. citizen or U.S. citizen, and a parent of an abuser who is a U.S. citizen. So that's the difference there. But the good part is, though, unlike the self-petition, there is no deadline after your client is divorced from the abuser, or if the abuser has lost status or has passed away. There's no 2-year filing deadline as there is for the VAWA self-petitioner. And in addition to that, there's no marriage needed if the abuse was to the child by the LPR USC parent. So that's important, right? Look at, do you have issues in demonstrating relationship to the abuser? And the one that we see most often, I think, is where there's been divorced more than 2 years ago by the time that your client comes to you for help. Or the other one that we've seen as well is the abuser has lost status and the self-petitioner didn't know about it. So that's important to kind of compare and contrast, and know that there may still be viable options to your self-petitioner, even if they're not eligible for a self-petition, or vice versa. The next one is a big one, joint residence requirement. VAWA cancellation does not require the individual to prove that there was joint residence between the the victim and the abuser, whereas the self-petitioner does have to demonstrate joint residence. So that's pretty major. It doesn't mean that you don't want to submit your evidence of joint residence. Obviously, you still want to show, if you're showing that the abuser was the spouse, you're still going to want to show, your good faith marriage evidence, and that might include your joint residence, but it's not a requirement. So that's important. Continuous physical presence. There's none that's required for a self-petitioner, but must be in the U.S., or some of these must have occurred in the U.S., with some exceptions, right? Whereas for cancellation of removal, there is a requirement of 3 years of continuous physical presence, but the notice to appear doesn't stop the accrual of continuous physical presence. There's a BIA case that found that the continuous physical presence under VAWA cancellation of removal continues to accrue up through the adjudication of the application. And same holds true for good moral character. Good moral character is 3 years. Under the statute for cancellation of removal, it's 3 years. Under the regulations for the interpretation by USCIS, their regulations state that there must be 3 years of good moral character. For cancellation of removal, it's the same as continuous physical presence. That cancellation of removal 3 years continues through the date of adjudication. So what does that mean? So it means that if the client had some action that may keep them from showing good moral character, and that action occurred, let's see, what was 3 years ago, 2016? In 2016, or let's just say 2017, right, within the 3 years. But the judge doesn't actually adjudicate the cancellation of removal application until 2020, then that may be outside the 3 years. As with everything else, of course, there are exceptions as to when the judge may look outside the 3 years, and also when USCIS may look outside the 3 years. But generally speaking, it's good to have that continuing counting of the good moral character. And then, with regard to inadmissibility and deportability, let's go back. For cancellation of removal, the person will not be eligible if they have aggravated felony, and the person must show that they're not inadmissible under 212A2, which is criminal grounds of inadmissibility. Not deportable under two. Sorry, I'm getting some feedback there. Is everybody on mute? There we go. I think we're good now. Whereas under the self-petition, you could have inadmissibility or deportability grounds, but they may be able to be waived, or there may be exceptions to them. For cancellation of removal, you do have to show extreme hardship. For a self-petition, you do not. And that's a big one. I don't know if some of you are new to VAWA self-petitions. Know that the USCIS regulations have not been updated in many instances, and so many of the statutory requirements of the VAWA self-petition, which have been updated through the various iterations of the Violence Against Women Act throughout the years. So VAWA 94 is different from VAWA 2000, from VAWA 2005. The regulations, the USCIS regulations, have not kept up with those requirements. So it's important to take a look at the statute and don't rely on the regulations necessarily for that. Did you have anything to add, Amy, before I move on?
I would just flag that you mentioned the false claim to citizenship issue, which is not included as one of the bars to cancellation for people who are inadmissible. But if you've got clients who are charged with deportability, then it is included under the 237 sections for the bar there. But like for self-petitions, there is a caveat to, so there have been some people who've been trying to apply the good moral character exceptions for VAWA cancellation, where you could still get a finding of good moral character if the violation was connected to the battery extreme cruelty. There have been people who have been arguing that that can be applied to the inadmissibility and deportability bars as well. It's a very creative argument. If you are looking at that kind of situation, we encourage you to reach out to us.
Yeah,
so there are potentially arguments for exceptions for many of these issues. Sometimes it takes a bit of creativity.
Yeah, absolutely. And obviously the reason for that is we don't have a whole lot of case law on VAWA, special rule cancellation of removal. So you can make those creative arguments. And yeah, so good moral character under 101F doesn't necessarily, or self-petitioners can be exempted from the 101F bars to good moral character in some instances. Yeah, and so do we have, Amy, in the materials, do we have the good moral character memo? USCIS.
I am not sure, but if we don't, we can send it out, and it's also on our website. It's also on the USCIS website.
Yeah, I just thought of it right now as we're talking about good moral character specifically. That memo is, I believe, from 2005, but even though it's so old, it is still in effect, and it's a good memo to make those arguments that Amy's talking about, or at least it's a good starting point, which just shows that Congress intended there to be exceptions specifically for victims of domestic violence, and USCIS actually implemented a generous application of those exceptions to a negative showing of good moral, to the bars of good moral character. Okay, so with that, I will go ahead and move on. So we mentioned, the last factor that we had mentioned was VAWA extreme hardship. For cancellation of removal, we do have to make a showing of extreme hardship. So what does that look like? Oh, sorry about that. So the regulation is listed there. But you're going to look at, does your client suffer from physical or psychological consequences of the abuse? Does the client need access to the U.S. legal system for protection? Will there be retaliation either from the batterer or the batterer's friends in the home country? Does the client or the children need special services for victims, which are available here but may not be available in their home country? So those are all the considerations that a judge should take into account when determining whether an applicant has shown extreme hardship for purposes of cancellation of removal. And remember that for special rule cancellation of removal, the extreme hardship is to the victim herself, him or herself, or to a qualified alien family member, right? Is that the term that they use, qualified family member? And so unlike cancellation of removal for all other non-lawful permanent residents who have to show extreme hardship to U.S. citizen or a specific U.S. citizen or LPR relatives. In this case, we're showing extreme hardship to the self-petitioner herself or the victim herself and or to their child. And so these factors here are important. There's also a USCIS memo. It's referred to as the Virtue Memo, when extreme hardship was a requirement of VAWA self-petitioning, USCIS issued a memo, and it was issued by, gosh, I don't remember the year, but it is very, very old. And it went through what USCIS considered extreme hardship. I still find that to be a really good guide, even though it's not necessary for VAWA. It's a good guide to help you as you are developing your case and coming up with the extreme hardship factors. And that virtue memo is in our materials today. So take a look at that. Obviously, it's not necessary for self-petitioning, but it gives you an idea of what the government is looking at when they, are looking at the interpretation of what is extreme hardship. So after looking at the regulation and what we just discussed as some possible factors, what evidence would you provide to show extreme hardship? You can use your chat box here. I know many of you haven't yet had to present a case before the immigration judge, but let's talk about it a little bit. What types of evidence would you provide to the judge to show extreme hardship? See, we've got several people who are typing, so I'm going to give this a couple minutes. Okay, so Ashley mentioned medical documentation. Someone mentioned a psychological evaluation of the victim or the qualifying relative. That's great, and make sure that if you want your psychological evaluation, one of the things that's a little bit different in immigration court is you want to make sure that you have the provider of that evaluation to be recognized by the court as an expert in their field or a qualified professional, right? So you want to make sure that you submit not just the evaluation, you want to submit their CV, have them available if your client is willing for cross-examination, if that's necessary, or get ICE to stipulate that the person is a qualified professional to make a determination on what your client has suffered. So that's a great one to include there.
I would also flag that in terms of psych evals, it's perfectly legitimate to include documentation from a domestic violence counselor or a therapist. There's no requirement that the individual making the evaluation have a psychology degree or be a clinical psychologist. What you're trying to establish to show the person's an expert is that they have specific training in this field, they have experience in the field that qualifies them to make that kind of assessment.
Yes, very good point. Thank you, Amy. And so the only thing I would add to that as well is, yes, it's a really good point because it's different from other types of cases also in that remember that the evidentiary standard is any credible evidence. So even if in other types of cases the judge would require certain specific evidence in order to establish, the various things, whether the client has suffered psychological harm. Even if you don't have a psychological evaluation, remember that you still want to make sure that the judge is accepting any credible evidence and not to a higher standard. So thank you, Amy, for going back to that point and explaining the differences. Yeah, it does not have to be a psychologist or psychiatrist. So other types of evidence to show extreme hardship would be the children's medical records or school records, and those could go to two different types of things, right? That could go to what the child has available to him or her here in the United States in terms of medical access if they have special medical needs. that they would not have in their home country. Same thing with school. It could be either they have special needs here, or what if the child is doing great here and wouldn't have the same level of education in their home country. I think there are various ways to be able to use the children's medical, various ways to use the children's medical and school records. And someone else said the IEP for kids, if they have special needs. Letters from a therapist regarding continued need. And so that's important too, right? So if you have a psychological evaluation to show what the client has suffered, that's one thing, but also including what the not just the diagnosis, but the prognosis, right? What is the outlook for them? What will they need in order to overcome what they have suffered, and whether that's available or not in their home country? That would be helpful. Affidavit or brief summary of the witness, order of protection, and photos. Affidavit or brief summary of the witnesses. Oh, okay. So, sure, you want to submit to the court in advance. This is the evidence that's being included. This is why I want it included as evidence, and you submit a summary of why those witnesses' statements should be included into evidence and given weight. Orders of protection, absolutely. If you have court orders showing that your client is currently under the legal protection of a state court, then that would be helpful in showing they continue to need that protection here and may not have it in their home country. So that is all extremely good. Amy, did you have any other examples that you would also use?
So just one point about this, and I think we should move it along since I want to make sure we have enough time to talk about the rest of the issues today, especially Sanchez Sosa. So one person raised the issue of having the therapist address the unavailability of mental health treatment in the home country. So if your therapist is qualified to make that assessment, let's say your therapist has experience providing mental health treatment in the home country and can talk about how hard it is to access, or has done other kinds of research that would qualify them to make that assessment, that's great. If your therapist does not have that expertise, I would caution against having a therapist say that, because it undercuts the credibility of what they're saying. So if your therapist is not able to talk about the lack of adequate mental health services, then that's where you're looking at other country conditions evidence to establish that.
Yeah, absolutely. Very good point there. Thank you. And then in terms of extreme cruelty, so what about extreme cruelty? What are we going to use to document there? If you are applying for a cancellation of removal, and so the judge is for the first time looking at the issue of whether the person has suffered extreme cruelty, if it may be possible, even if the person is not eligible for adjustment of status, to consider filing an I-360, or if you've filed an I-360 in the past and had that approved by Vermont Service Center, but your client is not eligible to adjust before the court and you're proceeding with cancellation of removal, you can use that adjudication, right? If it was favorable, if Vermont Service Center approved the I-360, then they've already made a finding that your client suffered extreme cruelty, if that's what you were proving in front of the Vermont Service Center. And so you make the argument that Department of Homeland Security should not now be arguing that your client has not suffered extreme cruelty. So an approval of an I-360 can really help someone to establish that they have suffered extreme cruelty and that the government has already recognized it. So just a quick practice pointer there. And if not, then we're talking about the types of evidence that we talked about just a couple of minutes ago when we're talking about extreme hardship. If you're documenting extreme cruelty, you're going to want to do it the same way that you would document it in a valid self petition.
And then also make sure to keep in mind that if your applicant for cancellation is a child, that extreme cruelty to a child can consist of having to witness their parent being abused, as an example.
Oh, yes, absolutely. Thank you. That's a great point. Okay. So let's talk about quickly other considerations for cancellation of removal. So the discretionary factors include lack of good moral character outside of the 3 years of the 3-year look-back period, whether the respondent remarried, whether respondent has been granted VAWA relief, or other discretionary factors, right? It's important to look at those before you're presenting your case in front of the judge. So even though remarriage, for example, is not a bar to filing for cancellation of removal, as it may be for an initially filed I-360, is that going to go against your client when the judge is looking at the discretionary factors of cancellation of removal, right? So it's not a bar, but is it going to hurt them in some way? In other words, would your client have eligibility to apply for some other form of relief through the new spouse, or does it undercut somehow other evidence that you presented of the length of time that your client suffered? So it's just one of those things where you want to look at that, but what it does not do is the remarriage will not bar. It's just a discretionary factor, and that's important. There is a BIA case law on that. And there's a couple of other BIA cases that we wanted to point out to you. Matter of MLMA, which is a BIA 2014 case. The BIA made a finding that a applicant for cancellation, special rule cancellation of removal, still warranted discretion, even though there was a fraudulent asylum application. And the respondent wasn't previously granted VAWA relief. It's all going to depend, right? Take a look at that case to see what was the balancing test, what were the favorable considerations that outweighed the very negative consideration of a fraudulent application, right? Let's see. Okay. So other discretionary factors. Criminal history, even if it doesn't affect good moral character, or it doesn't affect inadmissibility, or it doesn't trigger deportability, the judge can still look at those discretionary factors because, as you know, good moral character, they have to establish good moral character, and even if a person isn't inadmissible for a particular crime, it still may affect them in other ways. And so things that they're going to look at, right? So what if it's not a flat-out bar under 101F to a showing of good moral character, but they have a lot of them? One that I have seen, for example, is a person getting, well, this is excessive, but they had over 100 parking tickets and other violations. It never rose to the level of even well, in many of these cases, they didn't rise to the level of even a misdemeanor. A lot of them were ordinance violations. Some of them, there may have been one misdemeanor for a traffic violation. Obviously didn't make them inadmissible, didn't make them deportable. In and of itself, one would not affect good moral character. But if you're looking at their criminal history and there are just, this what appears to the judge to be a lack of respect of U.S. laws, then that might weigh negatively. So we always have to keep in mind, outside of good moral character, outside of inadmissibility, this discretionary factor that the judge has and how we're going to address that. And what I would say is address it right up front. If your client has any of these issues that are out there, you want to address it up front or be prepared to address it in the event that ICE brings it up, right? If you're not required, if there's not a question on the application that requires you to disclose it, there hasn't been any reason for your client to disclose it, but then ICE brings it up to contradict your client's testimony, always be ready, even if those factors wouldn't have made them necessarily ineligible for the relief. Okay, so I'm going to pass it on to Amy now.
Okay. So next up, we're going to talk about what to do when no relief is available and you haven't been able to get proceedings terminated, which is probably one of the more common scenarios that we're running across these days. So we're going to start with a quick poll here. Anna, could we pull up the poll, please? So I believe I have a removal case in which the client is not eligible for any relief before the immigration judge. So if you could put your responses in here, and then we can see. Let's just give it a moment. Okay, so it looks like we've got a smattering. Most people who do have cases and proceedings believe that their client is eligible for some kind of relief, but we do have a couple who say yes, and then a couple who are unsure. Let's end the poll. I would say that even if you do have if right now you don't have any clients who don't appear to be eligible for relief, it's possible that you will in the future. So it can be helpful to look at some strategies for addressing these cases since you're representing this person in proceedings and have to figure out something to do. Okay, so specifically, we're going to be talking about what if no relief is available and the client has a pending USCIS case, specifically a pending U visa. So if a U visa is pending, procedurally, you've got a few options. Your gold standard is going to be termination. You can use any of the arguments that we were talking about earlier. You could be very fortunate and get an opposing counsel who either won't oppose or may even join you. I would say that this is probably, practically speaking, less likely to occur, but your client is in removal proceedings, and so you really have nothing to lose in requesting termination to see what happens. So that's something to consider. If you are in a venue where the court has a status docket, you can request that. For anybody who's not familiar with status dockets, there are a number of immigration courts around the country that have essentially like a holding pen for cases that are not expected to advance in removal proceedings. So they're held on the side, they're not administratively closed. The judge isn't expecting you to file an application for relief, and they're just kind of holding the case, and you might be checking in with the judge every now and then to let them know what else is going on. Sometimes they'll do this for cases for respondents with a pending U visa. Sometimes they'll do it for respondents with a pending special immigrant juvenile status case or other types of cases before USCIS. If your client has already received an order of removal from the judge and it's up on appeal to the Board of Immigration Appeals, you can request a motion to remand based on the pending U visa. This is using essentially the same arguments that are presented in matter of Sanchez Sosa, which we're going to be talking about in more detail. And then the most likely procedural outcome, I would say, for people with pending U visas is going to be a continuance. So let's talk a little bit more about continuances. All right. So when we're talking about continuances for pending U visas, it's really important to talk about all of the different pieces of administrative guidance and administrative procedures that have been built in specifically to protect U visa petitioners. So we're talking about two ICE memoranda. One is the Vincent memo, and the other one is the Venturella memo, both of which are in the files. I'm sure many of you are already familiar with these. But these two memoranda, when read in conjunction, lay out a system for providing for stays of removal for people with a U visa petition pending who already have a final order of removal. It also lays out a system of getting people who are in active removal proceedings protection from removal, right? And all of this is consistent with the initial congressional goal behind the U visa program, which was to encourage undocumented people who were afraid of removal, afraid of deportation, to cooperate with law enforcement, right? And so the entire purpose of the U visa system was to try to diminish the level of fear in undocumented communities from coming forward. And obviously deportation is a significant part of that fear. And so these memoranda are written consistent with that congressional goal of protecting these people, right? And so under the memoranda, ICE is supposed to ask the Vermont Service Center for a prima facie determination of U visa eligibility. If the client is in removal proceedings, ICE is supposed to agree to a continuance and ask Vermont for that prima facie determination. We have heard that there are some offices of chief counsel that are interpreting the memo in such a way that they say that the respondent is the one who needs to request the prima facie determination. Our position is that that's an incorrect reading of the memo because the Vermont Service Center will not accept a prima facie determination request from the applicant themselves. It has to come from ICE. And then the reason why it makes sense for Vermont to be making this prima facie determination is that they are the ones who are ultimately adjudicating the U visa. And then also, if DHS itself, through the Vermont Service Center, is saying that the client is eligible for a U visa, then what is the purpose in DHS removing this client with a pending application? And then Sencha SOSA is another piece of what we call this protective web for people with pending U visas, right? And so just a matter of Sencha SOSA, for anybody who's not familiar, is the key case from the BIA that lays out what are the factors that an immigration judge should consider when determining whether or not to grant a continuance for a respondent who has a pending U visa application. And so it draws on factors from other types of cases and says that the immigration judge should see whether or not the respondent has a prima facie eligibility for a U visa. And then this intersects with the ICE memoranda because ICE is supposed to ask Vermont Service Center for a prima facie determination, right? And so we would argue that Vermont Service Center's positive prima facie determination would give rise to almost like a rebuttable presumption that the person is eligible for a U visa, that the immigration judge wouldn't have to redetermine prima facie eligibility where the Vermont Service Center has already made that determination. There are reports that some ICE offices are refusing to make this request, and so we encourage practitioners where this is happening to ask the immigration judge to require ICE to make this determination. You can also reach out to us if this is happening. We can help you try to work through it and potentially escalate it to other people in the agencies. And then it's, I think, important to consider raising these arguments if you have cases up on appeal to the BIA, you're asking for remand. You can use the same factors in Sencha SOSA to ask the BIA to remand the case to the immigration judge. And sometimes the BIA is much more willing to consider a motion for remand than a straight appeal, right? Because it allows the judge to make the initial ruling on these issues And then the BIA is then in a position later on of being able to review that decision instead of having to make the initial determination themselves. Okay. Next up. So one of the issues that's been coming up a lot is that last year, the BIA issued another case called Matter of LABR regarding the good cause considerations for continuances. The general rule is that in order to grant a continuance, an immigration judge has to find that there's good cause for a continuance. Matter of LABR lays out the general factors for what is good cause when a respondent is requesting continuances in immigration court. And then one of the questions that's coming up is whether or not Matter of LABR overrules Matter of Sanchez-Sosa. And our position is that Matter of Sanchez-Sosa is actually completely consistent with LABR. So Matter of Sanchez-Sosa would still be good law. So Sanchez-Sosa is really just laying out what the good cause considerations for a continuance would be for U visa petitioners. And Matter of Sanchez-Sosa is built on the existing prima facie system with the ICE memoranda that for the purpose of deterring U removals by ICE while the U petition is still pending. And then as I was talking about earlier, it's consistent with congressional goals, right? The entire purpose of the U visa program is to encourage undocumented crime victims to come forward and cooperate with law enforcement by decreasing their fear of removal, right? And so Sanchez-Sosa is consistent with that and is also consistent with the factors in Matter of LABR. When you are presenting your argument for continuance under Sanchez-Sosa, the considerations laid out in the case are going to be DHS's response to the motion, whether or not the case is prima facie approvable, and then what are the reasons for continuance, in addition to a couple other factors. So if you're looking at DHS's response to your motion for continuance, if ICE is opposing your continuance, yet also refusing to follow its own memo in requesting a prima facie determination from the Vermont Service Center, then we would argue that that refusal to cooperate and that opposition to your continuance is not the kind of reasoned, supported opposition that's contemplated in Matter of Sanchez-Sosa. And then in terms of the prima facie approvability of the case, obviously we would recommend that that you get Vermont Service Center to make the prima facie determination because they're the ones who have special training on this. If this is a domestic violence sexual assault case, then immigration judges don't have special training on victim issues, whereas the Vermont Service Center does. They have a special unit that is specifically trained to assess these kinds of issues. And so they're the ones who are really best positioned to make the prima facie determination as to approvability. As for the reason for continuance, ideally you're always able to show that the delay is being caused by USCIS. It's not your client's fault that USCIS hasn't gotten to your case yet, right? And so you also want to be careful that your client is not causing delay in addition to the delay that's caused by USCIS, right? Because if your client is also causing their own delays, then that could be a factor that might weigh against granting a continuance, even if your client has a pending U visa. Okay. In terms of making the prima facie determination, as I said, ideally Vermont Service Center would be the one making this determination. If you do need to make the prima facie showing to the immigration judge, then the primary issues that you're looking at are going to be, has your client suffered substantial abuse, mental or physical, resulting from the qualifying crime? There may be information about this in the certification itself. Also, it should definitely be addressed in your client's declaration. And if your client has been going to therapy or counseling for the mental abuse, then you can include that documentation as well. Also, certainly medical documentation if your client suffered physical harm. Helpfulness of the victim in Sanchez-Sosa is primarily established through the certification itself. So if you have a certification, we would argue that that establishes prima facie helpfulness. And then your client also needs to show the likelihood of the approval of the I-192 if they're inadmissible. And so there, most immigration judges are not going to be very familiar with the D-14 U visa waiver that Laura was talking about earlier with the national interest and public interest criteria. So you'll probably be in a position of having to explain what this waiver is to immigration judges in the BIA. Because the matter of Sanchez Sosa actually doesn't talk about the D-14 waiver except insofar as it talks about serious crime exceptions. So.
And then just really quickly, before we move out of Sanchez Sosa, this doesn't have to do necessarily with proper and prima facie factors, but there are two recent circuit court cases, one in the Second Circuit, one in the Eighth Circuit, which do specifically state that Sanchez Sosa is still good law. So the immigration judge at least has to go through the Sanchez Sosa factors before deciding to grant or deny a motion for a continuance. And then in addition to that, in addition to the Second and Eighth Circuit, the BIA itself, in unpublished cases so far, no published decisions, but in unpublished cases, has also come to that conclusion, right, that the immigration judge still should follow the factors of Sanchez Sosa, so that is still good law. And that's important because what we are hearing from attorneys across the country really is that ICE is making the argument that U visa cases take so long to adjudicate that that the continuance won't matter, right? That even if the judge continues for a year or for whatever the next date is on his or her calendar, that USCIS still will not have adjudicated because there are no visas available. These unpublished BIA decisions says that's not the standard for a continuance, right? How long a relief will take that's outside the control of your client is not the standard for how you decide whether a motion for a continuance should be granted. So keep that in mind, and if you are in that situation and are putting forth your first motion for a continuance, feel free to get in touch with us, and we can provide you with samples and look at the particulars of your case.
And Laura, you were going to provide links to those unpublished cases in the chat box, right?
I was, and unfortunately, it's not letting me link them. So what I'm going to do is after our webinar today, we are going to be sending you the recording. And so when we do that, I will include those unpublished decisions, the links to those unpublished decisions, and I'll also go ahead and include the Second and Eighth Circuit cases.
Great, thanks. Okay. And then as you are working on your continuance and hopefully getting that approved by the immigration judge, a simultaneous strategy that you might want to be looking at, especially if you have a client with really compelling factors, is whether or not you can get USCIS to expedite the U visa. So in general, it's pretty hard to get U visas expedited because there are so many people waiting in line already. And so it's difficult to show that your client merits expediting over the hundreds of thousands of other people who are also waiting in line. There are some situations that have, for which we've heard reports of success. So for example, if your client has taken voluntary departure and has a voluntary departure deadline, you may be able to get the U visa expedited. Also, if your client has been ordered removed and has a removal date with ICE already, you may be able to get that expedited. And in some situations, ICE would be able to get that expedite. But the fact that your client is in removal proceedings in itself is probably not going to be enough to get a U visa expedited these days. So what are the other considerations that might go into a request to expedite? A lot of these are very similar to issues that might go into a humanitarian parole type application. So if you've done those before, some of the considerations are very similar. For example, illness of the primary applicant or illness of other family members. And also if you have law enforcement that's willing to go to bat for your client and ask USCIS to expedite, then that can also be helpful. So there's some considerations that sometimes will help in getting a U visa expedited. In general, it is quite difficult. So it's something to look into if your client has super compelling factors. Generally speaking, expedite requests are going to be more successful if they're coming from some kind of government agency, but not in all cases. Okay. And then just to wrap up, a couple quick polls. So one is, if my client has been granted U non-immigrant status but is also in proceedings, my local Office of Chief Counsel will, and your options are, move to dismiss the notice to appear, join my motion to terminate, oppose my motion to terminate, not respond or do anything, or reissue the notice to appear and charge my client under 237A for deportability.
I'm not liking the options yet. Not responding. Uh-oh.
Yeah, so we'll just give it a couple minutes. I know there was a mixed bag of people in the audience who have clients in proceedings and clients who don't. So we'll just give it a couple seconds here. Okay, so it looks like one person says OCC will join their motion to terminate, which is excellent. That is what they should be doing, that or moving to dismiss the NTA themselves. Two who will oppose their motion to terminate, and then quite a few who say that their OCC will not respond or do anything, which is consistent with what we've been hearing from other practitioners. Okay, let's go ahead and end this poll. So there is an argument that we think is a very good argument that if your client has been granted U non-immigrant status, they're in lawful non-immigrant status. And so if they were being charged for inadmissibility as being present without admission or parole, or lacking a visa, or things that have been overcome by the grant of U non-immigrant status, then they should no longer be removable. There's an unpublished case on a T visa case that's in your files from June. There's also an older U visa unpublished case from, I think, maybe 2 years ago or so, where the BIA says that a grant of U non-immigrant status is a grant of admission. The more recent T visa case is, I believe it was granting a motion to reopen, was that what it was? Where the person had been granted a T non-immigrant status to overcome the removability. And so we would certainly argue that OCC should be moving to dismiss the NTA of their own accord, or at least joining your motion to terminate. Or if they don't oppose, then that could work as well. But they definitely shouldn't be opposing your motion to terminate. Okay. One more poll here, if we could pull this up. So if your client has been granted U non-immigrant status but is also in proceedings, now your local immigration judges will terminate or dismiss proceedings, put the case on the status docket or continue proceedings, order removal if no relief is presented, other, or depends on the IJ. So I'll just give this a couple seconds here. All right, so most of you guys are saying that the IJs will terminate or dismiss proceedings, which is excellent. That's what they should be doing. Depends on the IJ. That's not surprising. But again, they should be terminating or dismissing proceedings because your client is now in lawful status and should not be removable from the United States. I am really glad to hear that nobody's IJs are ordering removal. We have heard that from some practitioners. So I don't know if our audience today just isn't in those venues, or if that problem has been alleviated. But they definitely should be terminating or dismissing in cases where your client has been granted status. All right, let's close that poll. Okay, and Laura, you're up. I think we're going to have to go relatively fast on this section since we're a little short on time here.
We wanted to focus most of our time on the prior sections of what to do when you're in removal proceedings. What we're going to talk about now is what you do when relief is denied. So when you represented your client, but they're ordered removed, or if you have a client that has already been ordered removed, what do you do for your VAWAs, U's, and T's? So let's start with voluntary departure. If they have no relief and your client is in removal proceedings, many people say, should I just apply for voluntary departure to get them some more time, because the judge can give them some time to take care of their issues before they leave the United States, and they leave on their own accord. It's not as traumatic. That's only going to be an option if your client is actually going to leave the United States, right? In some cases where they have a family-based petition and may be eligible for an I-601A waiver of inadmissibility, they may want to do this, take the voluntary departure, prepare themselves, and leave on their own accord, and then file, and in the meantime, file their I-601A waiver while they're still here, and then consular process their immigrant visa. In some cases, it makes sense. But in many of our cases that we're seeing where the person will have the ability or has a pending U, pending T, but not yet an approval, and now is faced with seeking whether to seek voluntary departure or not, be very careful. While an order of removal will result in yet another ground of inadmissibility for purposes of your U's, VAWAs, and T's, an order of voluntary departure, if the person does not leave the United States, so does not comply with the voluntary departure order, there's a bar to adjustment of status. That's really important to note, that the bar to adjustment of status for failure to comply with a voluntary departure order does apply to your U's and T's who are seeking adjustment. Well, specifically, there's a AO decision that indicates U's are subject to it. VAWA self-petitioners, there's an exception if the abuse is at least one central reason for failing to depart. So again, there's an exception, but it's limited. So be careful when you're looking at whether or not to take voluntary departure. And realistically, the other just quick practice pointer is you want to be thinking of this before you're ever in front of the judge your first time. The pros and cons of voluntary departure and whether you're going to be seeking it as an alternative relief if your case is denied. So let's talk about appeals, right? So you're not going to take an order of voluntary departure. Instead, you're going to appeal to the BIA, which is something that you should do in order to keep a case alive. So if you have a pending U or T, or if your client is just in the process of applying now for a U and T, you want to keep that underlying case open and not have a final order of removal, because the final order of removal doesn't enter until the BIA has made their decision, right? So the notice to appeal must be filed with the Board of Immigration Appeals within 30 days of the IJ's decision. And what you need to include in your notice of appeal is what was the error made by the IJ. So if you're appealing after the IJ denied a motion for a continuance and issued an order of removal, then you may assert that the IJ didn't conduct a proper Sanchez Sosa evaluation of the case, whether or not they were eligible for a continuance, which would have kept the case alive. Did the IJ ignore evidence of extreme cruelty or extreme hardship? Did the evidence weigh the discretionary factors appropriately? These are the issues that you want to assert. And then, of course, as we talked about before, did the IJ apply the correct evidentiary standard? Because if it was a VAWA case, for example, any credible evidence is allowed, and we want to make sure and hold the IJs to that standard. If you're in a situation where at this point there has already been a final order entered, and you are either picking up the case now or had the BIA denied and now you're seeking to reopen, there is a possibility of filing motions to reopen. Generally, the standards are that there must be new facts and evidence that was not previously available, and it has to be filed within 90 days, but there are certain exceptions to that. And we'll talk about some of those in just a minute. What are the options or benefits? What type of relief would your client be eligible for now? Is that the new fact or evidence that you're going to be submitting? You want to include that in there. And it may be beneficial to your client as well, right? If filing the motion to reopen together, and it is reopened, and you have an I-485 that you can file, your client may then be eligible to also file an I-765. So it may be a good option if your client is eligible within the standards of a motion to reopen. In absentia orders, in absentia orders, there's a really good reason to file a motion to reopen where there was an in absentia order, because filing a motion to reopen when there's been an in absentia order results in an automatic stay. And if your client already has an outstanding of removal and ICE is looking to remove them, this will be important. And then, of course, motions to reopen can be a remedy for voluntary departure. So let's just talk quickly about a VAWA motion to reopen. The general standards that we just talked about, the 90-day rule, for example, wouldn't apply to a motion to reopen for a VAWA self-petitioner or VAWA cancellation applicant. So they have to show they're physically present in the U.S. The 1 year from the final order there can be an exception to that 1 year from the final order if they can show extraordinary circumstances or harm. And so there's legislative history, the congressional record, which is in your materials, on what those extra circumstances are, include, the atmosphere of deception, violence and fear, making it difficult to learn or know how to defend yourself against removal, and reopening the removal, the child's age, etc. So look at the congressional record and see if there are these additional extraordinary circumstances that should be taken into account when the BIA looks at the motion to reopen. And then again, for VAWA motions to reopen, there is an automatic stay, just as there is for the in absentia order. So what would you do? Patricia believes she was ordered removed in absentia.
Hey, Laura?
Yeah.
Laura, might I suggest that we skip this one?
Okay, sure, because I was going to go through the other ones more quickly, but that's fine. We can go ahead and skip it. Okay. Okay, so sua sponte motions to reopen. A sua sponte motion to reopen is a type of motion to reopen that you would want to file when you have a client that's eligible for relief now that maybe they weren't eligible for before. So, for example, your client has an outstanding final order of removal, but they now have U or T visa status. You would file a sua sponte motion to reopen, in other words, asking the immigration court or the Board of Immigration Appeals, depending on where the final action, depending on which one has jurisdiction, you'd ask them to reopen the case of their own accord in order to have the case terminated or in order to take that final step, let's say in the case of a VAWA self-petitioner who now has an approved self-petition. And in drafting your sua sponte motion to reopen, the goal is obviously to get that old removal case reopened and then terminate, specifically based on you non-immigrant status, or you can also have it reopened, as I mentioned, if you now have an approved T or VAWA self-petition where you can now apply for adjustment of status. Use the arguments of public or national interest that you've already used, right? So if you had a waiver and you already overcame that that criteria of showing that the waiver was in the public or national interest, show the judge the judge or the BIA the same type of evidence in showing that a sua sponte motion to be reopened would be appropriate. And then finally, stays of removal. This is something that you should always have ready and available or be ready to file if you're taking on a U or T visa case where the client already has an outstanding order of removal. Have your I-264, which is the form to file with DHS with ICE and the filing fee. And basically, you're going to ask DHS to stay the removal of your client pending the outcome of the U petition. You want to show, it's discretionary, so you want to show the same type of positive evidence and equities and hardship, everything that you would have shown in your U to get a waiver. You want to submit that same type of evidence for to ICE with your stay of removal, and obviously have your basics covered, have your receipt notice for your U visa, have your law enforcement certification, which usually can go a long way with ICE. And if you do have a situation where you're filing a stay of removal for the first time, feel free to get in touch with us. We do have a sample and obviously can help you make those assessments in your case as to what would be the strongest way to present it. So the takeaways are obviously plead carefully if your client is removal proceedings. Remember VAWA cancellation as an option when you're first meeting a client, right? It's not always going to just be adjustment of status. Stantia Sosa is still good law, as we discussed, and as the cases that are in your materials will show. File a FOIA. We haven't mentioned it yet, but absolutely file a FOIA if your client has ever been in proceedings, thinks they might have been in proceedings, thinks they may have had some contact with immigration, and be prepared with your stays of removal. Unfortunately, we don't have time for questions, but there is our contact information. We really appreciate you joining us today. Feel free to reach out to us if you do have questions on this particular presentation, or if you need technical assistance, you can submit your technical assistance request and one of us will be happy to work through these issues with you. Thank you again. Have a great rest of your day.